Welcome back, ladies and gentlemen. Today we have three current and former corporate counsel, in-house counsel, from some very reputable firms who've got tremendous experience retaining, engaging in, defending, and otherwise seeking. Is that? I don't really want to. There we are. That's good. Right. So in particular, we'd like to discuss with them their experience working with corporations, arbitrating internationally, but in particular the GCC and the relevant territory, as well as the kingdom. So let's begin with introducing our three colleagues. We have, to my immediate left, Mr. Abdullah Al-Ghamdi, Chief Counsel and Manager of Litigation and In-House Advisory Department at Saudi Aramco. He manages a diverse team of attorneys responsible for Saudi Aramco's in-kingdom disputes, as well as the provision of legal advisory in relation to Saudi laws and regulations. Welcome, Abdullah. At the far end, we have Mr. Sean Yates. For many years, and until last month, he was General Counsel of China State Construction Middle East, and now is with Outer Temple Chambers, UK, but based here in Dubai. And between all of us is our very learned sister, Maria Scanlan, Senior In-House Counsel and in-house lawyer for over 20 years since she qualified. Today, she's Legal Director at Crescent Petroleum. And before her arrival at the UAE, she was Head of Legal for one of the largest teams at Royal Bank of Scotland in London. Whilst in private practice at both US and global law firms, she focused on international arbitration, complex litigation, regulatory investigations, covering a variety of sectors. So before we open it up to questions, which I really think is the most fun session, or part of it, I just want to open up with a couple of quick questions for each of them. But the focus, obviously, is what interests us all here today, which is what are they looking for as corporate counsel? How do they measure? And how does KSA, SCCA, et al. Measure up for you, your company, your industry peers, and legal practitioners? So we'll go straight in with Mr. Abdullah Al-Ghamdi. So Abdullah, candidly, what does Saudi Aramco, what has their experience been with ADR? And how does Saudi Aramco currently use arbitration within its agreements?
Well, thank you, James, and good morning all. Assalamu alaikum. I would like to first start by thanking the Saudi Center. Can you hear me? Yep. Can you hear me now?
Maybe just borrow the microphone.
Questions? How about now? Perfect. Well, good morning all. Assalamu alaikum. Thanks, James, for the introduction. Before I respond to that question, I would like to first thank the Saudi Center for Commercial Arbitration for arranging and hosting this symposium. It's such a great opportunity to be meeting with ADR experts and colleagues, and I look forward for a fruitful symposium. We do value our relationship with the SCCA and Saudi Aramco, and we're glad to be the diamond sponsoring entity of this event, and we look forward for a future cooperation as well. Before talking about our experience with alternative dispute resolution, I would like to briefly describe how we view our contractors and suppliers in Saudi Aramco, because such view paves the picture on how we deal with disputes arising from such a relationship. We tend to view our contractors and suppliers as partners towards the success of the company, and we both have mutual interests and objectives that we're trying to attain. Therefore, any dispute arising from such a relationship is treated a bit slightly different than our quintessential or typical disputes. In Saudi Aramco, James, for decades, we've been implementing a claim-stepped process. And this claim-stepped process is enshrined and contractually agreed upon in our contract, with an aim to amicably and swiftly resolve any dispute that could arise from such a relationship. Now, this stepped approach starts with escalating the matter within the respective senior management of the entity. So, for instance, if Saudi Aramco has an issue with the performance of one of the contractors, we would simply approach the senior management, and vice versa, they would approach our senior management to try to resolve this issue. Assuming that a resolution is not achieved through this initial stage, then the contract calls for escalating to an independent internal expert. And by independent, I mean an independent from the subject of the contract. Typically, we often find that the dispute relates to a misinterpretation of a technical clause, for instance, a schematic that went wrong. So the expert might be able to resolve the dispute and clarify the ambiguity, and parties would commence and go on towards implementing the rest of the contract. Should this stage does not materialize into an amicable resolution, then the next stage within the contract is to escalate to a three-panel committee, an internal three-panel committee, again, independent from the subject of the contract. And this panel would typically engage with both parties, understand the dispute, review the documents, and issue an opinion. It doesn't stop at there. If the parties are not satisfied with the outcome of this panel, an appeals panel is also created, and all of those panels are creature of contract. So the appeals panel will again review the matter. It consists of 4 experts. And if the resolution is not satisfactory, then each party is allowed by the terms of a contract to seek external resolution, i.e. either through litigation or arbitration. And interestingly, most of the disputes and claims that arise from our relationship with our contractors gets resolved within this internal ADR. Typically, in a single time, we would have almost 3,000 active contracts with a value that exceeds tens of billions of dollars. And only a handful of those contracts would actually reach a level where each parties would need to litigate or arbitrate. So this process has been proven, this ADR process has been proven really excellent in terms of addressing ADR or addressing disputes with our contractors. In fact, this allows us to have a sustained relationship with our contractors, which some of them spans more than 50 years. So this is, in a nutshell, Aramco's experience with ADR.
Thank you. Thank you. So now, I think I'd like to turn to Ms. Maria. Of your experience as in-house counsel using ADR, particularly arbitration, what might you be able to share with the balance of these people being practitioners in counsel?
Yeah, so in my experience has varied quite a lot from the time that I was in banking in the UK, where arbitration wasn't really the preferred option. It was usually mediation and then court proceedings. But obviously, moving into the oil and gas industry, arbitration really is the bread and butter of our dispute settlement mechanism. And we also have multi-tiered disputes in a lot of our contracts. What I wanted to share in the context of this forum is that a lot of the time, the reality is that commercial contracts, the arbitral institution rules that apply to a commercial contract are not always driven by the fabulousness of the rules that you're talking about or the procedures. As an in-house counsel, I think the reality is that a lot of the driving force is really the familiarity with the rules. And a lot of the time you really have to convince your stakeholders who are very familiar with specific rules to be quite open-minded and think about, what other rules are out there that you could be equally comfortable with. And, a lot of their experience in terms of, past outcomes and past arbitration awards and, past precedents, and then geographical affinities definitely drive the arbitral institutional rules that you end up choosing or that you end up promoting as an in-house counsel. So I think that being in this kind of environment, having these training sessions with the likes of the SCCA is crucial for in-house counsel because we need to be the ones that convince our stakeholders that these are arbitral institutions that are world-class. And so coming to these events, is really an educational tool for us. And I really encourage, and it's been really encouraging to see that the SCCA is placing a lot of emphasis on capacity building and training and educating people, not just the law firms, but actually in-house counsel on the the features and the uniqueness of those rules. So we talk to our peers. We ask them about their experiences with certain arbitral institutions, and I actually, on that note, I really found Christian's stats. I don't know if he's around, but the stats presentation that he put together really helpful, thinking about enforceability, about the reasons for annulment. I mean, these are obviously issues that we consider internally as in-house counsel as well. So having that transparency, I think, is hugely valuable, and that allows us to be able to sell a particular arbitral institution to our stakeholders internally.
Thank you. Now on to Sean. So Sean, although now you're a barrister once again, if you can look back into the mists of a few weeks ago and previously, obviously everyone here is particularly interested, I mean, quite literally catnip, if you can share the insights as to how, when you were with the Chinese institution, the construction entity here, how was that going in terms of arbitration in the region?
Okay, thank you. It's a pleasure to be here. I can hear my own voice, so presumably you can hear me as well. It's probably less glamorous than you think. I'm not sure I'm going to be giving away many trade secrets, but the reasons for selecting particular institutions were those that were, I couldn't put them any better than Dr. Waleed set out earlier, that really we are looking for the same things. We have the legislative responsiveness, judicial cooperation and support, independence and good governance, and the offering of a complete or comprehensive range of services. That's what we would look for. But there's probably a difference between the ideal institution and how we would like disputes to be resolved, the process through which we would aim to put them, and what happens in reality. Because in construction contracts, which often have a very long life cycle, and that I think is one of the distinguishing factors between construction contracts and others, and we'll speak more about that on one of the subsequent questions. But because of that life cycle, it's during the tender process when we're negotiating with our counterparties that we will look to adopt the relevant dispute resolution clause. Tinkering with that or changing that in any dynamic way just doesn't seem to happen, because the tender people are less interested in potential disputes that may arise down the line. They don't think of them. We have to keep reminding them that things do go wrong more in construction contracts than others, perhaps, because of the complexity, the fact that there are lots of contracts within a contract, and because of the chain supply and because of the duration. There's a lot more potential for things to need the intervention of a dispute resolution mechanism that's effective. But when we're looking at it, the tendency is to use the standard clause that has been used before. So as a legal department, we had to be fairly active in horizon scanning to see what was changing, which centre would probably be best suited, and then persuading management and then explaining to the department why we were recommending a change, if a change was to be provided. I'm not now in a position where I'm doing the same job, but I would still take similar factors into account. And responsiveness is particularly important. And I'm still wide-eyed at learning what SCCA has been doing most recently. And their responsiveness is there for everybody to see. We've got the companies law. I'm not being paid for this. It's the response to the new companies law in Saudi. We have the opening up in Dubai, which I think is pretty impressive, because I moved into the DIFC 2 weeks ago. It only took you guys 2 weeks to decide to open an office and get it moved. So that shows how responsive it really can be.
We only came because you were there. But then again, thank you very much. In terms of Maria, a two-parter, if you will, following up on what Sean was talking about, selecting institutions. What are the criteria most important to you when selecting an arbitral institution and its rules? But secondly, is there anything in particular at SCCA rules that might appeal to you as in-house counsel?
Yeah, I think very similar to what Sean said. We really look at world-class rules, and rules that have a proper procedural framework. Limited judicial intervention. Enforceability, obviously, of the courts of the seat is also important. It was, again, extremely helpful to hear from Christian about, how the kingdom is actually moving towards a much more arbitration-friendly seat. And also, having the proper balance between a lot of transparency but also confidentiality is highly important, I think. Cost and time efficiency is a factor, obviously, for us. We don't want a process that's overly expensive, especially when you've got an extremely high value claim. You're stuck with ad valorem. You need to have a bit of flexibility. And also a process that's quite responsive and not overly bureaucratic, and that allows you sufficient procedural flexibility to, have access to things like expedition of, emergency arbitrator appointments and expedition of proceedings and that sort of procedural expediency mechanism. And in terms of what would make me consider the SCCA, other than the big, enforcement discussion that we've had, I think, to me, today has been hugely informative because it's really shown me that the Kingdom's vision for 2030 is being taken extremely seriously. And, as an example of that, there was a real push to make the SCCA a world-class institution. Again, I'm not being paid to say this, I'm, genuinely as an observation. And it gives me a lot of comfort to see that we've got an independent SCCA court that's got the likes, of Jan Paulsen and preeminent arbitration practitioners who are well known in the wider arbitration world and deserve their place there, and also, an independent board of directors, including Professor Wahab, and there's people that we know in the industry that we've worked with. And whose reputation really precedes them. So their giving their blessing to the institution is really, really important to us as in-house counsel. And in terms of the features, again, as I mentioned, having that flexibility with everything from arbitrators' fees, having the ability to have alternative fee arrangements and making the process more cost efficient is really, really important to us. And last but not least, I think I echo your views that having a local presence is really important, being able to go and see how these people work and to get to know the people that work for the SCCA locally. And also, hearing from your peers who have probably already used the rules. That's crucially important, having that transparency, that communication. And then, going back to being well educated about what's on offer. That's really what attracts me to it.
Thank you very much. I'm going to pivot back to our new neighbour, Sean, at Currency House here in the IFC. Sean, elaborating on your experience with construction companies arbitrating the MENA, but specifically, if you could focus on what can governments, institutions, and practitioners do to address any issues or challenges that might arise, i.e. to thereby help make arbitrating in the region and in the Kingdom more appealing and more efficient.
Okay, I did have an answer. I had one answer to this written down, but I've thought of another one that I think is more interesting. If we look at the reason why parties use institutional arbitration rather than ad hoc, it's essentially because we're looking for a support system. We want a certain process that's identifiable, predictable, something where we know what's going to come next. And it goes back to one of the first points I made about responsiveness. It's not just responsiveness to the latest developments, it's responsiveness to what the users, what the parties are looking for. And I think parties use institutions more or less, to a larger or lesser degree, at various points in the process. Once the tribunal is appointed, your first main contact is going to be to the institution itself. But when parties commence arbitration, they're quite apprehensive. It's quite unsettling for parties to think they're now having to press the button and potentially compromise this relationship that may have existed for a long time with a counterparty. They're having to ask for intervention, for somebody else to decide who's right and who's wrong. So they are apprehensive at that point, and they need responsiveness. They need help sometimes when it comes to the appointment of the tribunal, for instance. It's a very intense process, and I think it's important for parties and users to feel that they're being looked after. Now, institutions recently, they've been administrative, they've been process-driven, And the perception is that that is predominantly what they do. There's been a tendency to see, it's been difficult sometimes to differentiate between some institutions because they started to mirror each other. There's a lot of mimicry. Look at what happened when COVID hit and there was a need for dealing with matters online. We saw protocols within weeks of each other being issued by different institutions. They're copying one another so that they were all offering pretty much the same thing. So that was good because we had a high level of standardization internationally with institutions responding to what the users wanted. But what I've heard today, this looks like a new level, a new type of institution. It's offering more, it's taking more of an interest. We're looking to the institution for guidance on enforcement as a result of case law analysis that's happened within the kingdom. That's going well beyond what institutions normally offer. And so I think we're now looking at the growth of a new type of institution with the SCCA setting the standards, where we've got much more interaction. Parties are being educated by the new institution. They're being involved by the new institution. The fact that SCCA is here, I think, shows that they care, that they want to be here, and it allows a two-way flow of information because users can approach them here. They can speak to Fatima, say, we want this. We'd like to see this. How can you improve this part? If institutions are remote and we treat institutions simply as providers of rules or purely administratively, I think there's a two-dimensional element where we lose that interaction that we get when we can turn up. And that's the importance, I think, of being here, as Maria was saying, that we want to be able to approach in person, if possible, if there's an issue. Then as users, we feel looked after, I think. So that's I thought that was a way of saying discreetly that my time is up. But I think this is something new. I'm impressed.
There's always been a very strong bond that was alluded to by the Rais and others today between the different jurisdictions. And even many years ago, the Saudis sent 20 judges to a in-depth session that we were holding on ADR in Bahrain. And then subsequently, ICCA was involved with the Middle East Judicial Dialogue and so on and so on. So it's this collegiality that's going to make a big difference. And speaking of collegiality, our friend, Ustad Abdullah, Aramco obviously plays an outsized role in the kingdom itself and beyond because of its centrality and role and size and scope. But they're often called upon to get engaged a little more widely beyond your usual energy remit. And one of them was this idea of, because you obviously believe as a corporation in the utility and efficacy of ADR, if you could just speak briefly, and this is the last question before we open up to the floor, can you elaborate a little bit on what Saudi Aramco has been investing in terms of promoting ADR more generally?
I'll try to be brief, James, although I have a lot to talk about ADR when it comes to our practice in Aramco. As I explained earlier, we pride ourselves that we're strong advocates for ADR. We've been using the ADR process for decades. And most recently, we've been incorporating the relevant provisions in our contract to have the SCCA as the institution that would administer the arbitration. In terms of what we're doing, I would divide them into two folds. The first is internal and the second is external. Internally, within Saudi Aramco, we tend to cooperate with our internal clients, as we call them, the different organizations, the customers of the contracts within Aramco, to educate them about the alternative dispute resolution process that are typically enshrined in our contracts. Externally, obviously, participating in such events is a key element for us to, in the realm of ADR, and working with our colleagues in the SCCA as well. We in Aramco also are exploring means. Dr. Mira mentioned the moot courts and the moot arbitration courts. In fact, in Aramco, we are also exploring establishing cooperations with the local universities in the kingdom with regards to delivering even lectures, sending our inside counsels to participate in the lectures and the sessions in those universities to educate and to make sure that the law school students are aware of the different processes towards resolving disputes. Also, we're also exploring with them possibilities of sponsoring moot courts and overseeing moot courts when it comes to arbitration. So we're doing a lot. There's a lot to talk about, but I will defer to you.
Thank you so much. Excellent. Thank you, Abdullah. So we have a great group of people. If we can see a hand, someone will come to you with a microphone. We have one hand there. Do I have a second? Going once. Allons-y. Tafadhal, if we can hook up this gentleman on the aisle at the back. If you can stand and introduce yourself as well. Thank you.
Hello. Thank you for the esteemed committee. Just one question as a lawyer and usually drafting contracts. The traditional trend when you choose or arbitration, you would tend to focus on the place where the contract is being executed just to get the best cultural and more relevant expertise in that area. And listening to other commentators, they are trying to move like SCCA to work in Dubai or to have a global presence, though it has a Saudi focus, Saudi presence more than any other institution in the Saudi Arabia. So, as a counsel, is this the trend that you are following? Meaning that you would choose the institution that is best equipped in the area where the contract is reported, or would you venture in other institutions?
Who wants to?
Yeah, I mean, there's no denying that you do look at the enforceability and you look at the seat. There's no denying that you look at the seat as as the kind of primary driver when you're choosing the seat of the arbitration. In terms of the institutions, I think once you've got confidence that the arbitral rules that you're dealing with have got a very similar standard on offer to the ones that maybe most people are better acquainted with, then I think I would be willing personally to use those. What we find is that a lot of our contracts tend to be English law contracts, so there's a natural tendency to go for a London-seated arbitration clause under, LCIA rules. But being a GCC company, often we enter into contracts of all kinds, including, with consultants and other local companies, which you historically have wanted to use a local seat. So they may have used the LCIA, DIFC arbitral rules with DFC seat, and obviously since the conclusion of the LCIA DIFC institution, a lot of us had to think quite long and hard about do we just revert to LCIA, and some counterparties are not really familiar with the LCIA, so they prefer to opt for a regional, arbitral institution. So we have to be open-minded, I think, is the key in terms of the rules that you use. But yeah, I mean, I would say that enforceability of the award is a primary concern.
Thank you. Well, I think it goes back to the point I made briefly earlier, that there was a tendency to delocalize rules. Arbitration, international commercial arbitration in particular, is a delocalized process. Much is made of this, as many of the people in the audience may have written about the delocalization of international arbitration, which effectively says that it's anchored to particular jurisdictions when it comes to enforcement or curial issues. But for the most part, it is a process which is owned by the parties. So theoretically, you can operate from your dispute based on a center that is remote and according to rules that are remote, because it shouldn't matter. And I think again, traditionally, the way that you would ensure that, in response to the question, the process was one that was suitable and most effective for a local contract with local issues, with local law, would be that you would appoint local arbitrators. So it was your choice of arbitrator and tribunal that would ensure that the particular local issues were dealt with properly. The rules, many rules started to look like everybody else's rules. There were slight differences, and we were aware of the ICC's review of the award, which happens in other centres as well, but it was a big thing about ICC. This is what they do. So you've got a certain quality check on the ultimate award that was issued. But where your centre was and which rules you adopted mattered less. I think there should be some rethinking now that centres are, if they follow the SCCA model, are offering much more than just a set of rules which you can adopt and implement in the way you might a dispute resolution clause. It seems there's a lot more active involvement, and that would be a differentiator in which institution might be selected.
Incidentally, a lot of the step clauses will mention the arbitral institution for the arbitration piece, but not mention it in the mediation piece, which is how I get so many ad hoc cases. And it's this changing of things in midstream just doesn't happen. The parties, I asked them, why didn't you go through this center or that center? You know, I'm on the roster to make things a lot smoother, et cetera. They said we couldn't get them to agree to anything. So I do hope that everyone will start including the mediation element, that portion of the proceedings in the clause itself, and align it with an institution. That would be helpful. Next question, please. 1, 2. Okay. Can you give this gentleman the microphone?
So I wonder what feeling that
Can you stand up? Sorry, it's it.
Sure.
Okay.
I wonder whether there's a feeling amongst general counsel that a lot of institutions have moved to rather prescriptive rules, effectively taking a bit away from party autonomy. So whether, how a dispute is being classified, that is under expedited rules or deadlines, and whether there's a feeling that we've gone to, I mean, what you've been described as administrative arbitration, perhaps not, but in a much more sort of hand.
Can take a stab at this. Thank you. I think clarity is important. If the parties, when they enter the contract, they know, God forbid, if there is a dispute, they know what rules are going to be applied, then we tend to find that really helpful. Some, like the SCCA rules, for instance, they provide for fast-track arbitration. For instance, in our contracts that value less than $1 million, the SCCA would typically appoint one arbitrator presiding over that with an expedited process. So that's really helpful. We haven't tried it yet, which is a testament to our ADR process. But in the event that it happens, we have full faith in the institution. So I guess the bottom line is clarity, especially in large contracts. People want to have a sense of what could happen. So it's a balance between being super prescriptive and ad hoc in the same time. You need to strike the right balance in the drafting.
I think many rules did start to resemble every other set of rules. You have some outliers like the Prague rules. If you wanted a document only or predominantly document only assessment, then the Prague rules were the ones to adopt. That was what we would hear. But I think arbitration is different things to different people anyway, because the freedom that exists within arbitration means that it tends to be tailored and usually actually reflects the local litigation process to a large extent, because you have local lawyers who are trained in a particular way from a particular jurisdiction, and they would have control over the process. So you find that construction disputes that are arbitrated in the UAE very much resemble a Western common law approach to dispute resolution. Whereas at the same time, in France, with civil law practitioners who are used to a different approach, the procedural order number 1 that emanates from those proceedings probably looks quite different, and the whole process more resembles the state court process, because lawyers do what they're comfortable with and they mimic the outside process. It's particularly interesting in the UAE because we have a mix of those who are from a civil law tradition background and those who are from common law family background, and they have different approaches to dispute resolution. They have different ideas because of their education as to the sources of law, what's important, what isn't. And one of the most interesting parts of practicing here in the field of commercial arbitration is when you get different parties on either side that are from different traditions, which is a clash that you don't see within any given court system because everybody belongs to the same system and they're following the same rules. But when you get civil law lawyers on one side, common law lawyers on the other, and then an arbitrator who might be from a different system altogether, it's amusing, or it must be amusing to somebody, the fly on the wall perspective, watching them trying to work out how the process is supposed to run, because each side's absolutely convinced that the other side doesn't know what they're doing. So it's an interesting time to be here. I think there is certain standardization because of rules, because practices develop over time. But ultimately, international commercial arbitration is not owned or completely dictated in terms of its process or its development by any one country or jurisdiction. It's everybody here. It's the international community that decides what's going to change, how it's going to change, what's going to be best for arbitration. And that's how the evolution within arbitration happens. So I think in terms of prescriptive rules and more or less prescription, I think you might not find that from particular institutions. You may find it as a more of a localized practice.
Yeah, I would agree with that. And as somebody who practiced in the English courts for many years, I can tell you that arbitration is far less prescriptive than having to pore over the white book and all the civil procedure rules that go into the court process. So for me, it's a relief to be doing arbitration again.
So we can come back for a supplemental in a moment, but if this gentleman at the back and then this gentleman in the front row. Thank you.
Thank you. My name is Asadin Masiri, lawyer and arbitrator. I would ask rather a legal question. What is the position of the SCCA rules and the Saudi law with regard to the extension of the arbitration agreement to non-signatory parties, especially that we find these cases are frequent in construction disputes? Thank you.
Thanks for the question. Perhaps this is more a question of a Saudi scholar, but my understanding is that the Saudi arbitration law prescribes certain process on how to extend the arbitration proceedings, and our experience, at least with that, my personal experience, is that typically the law itself, the Saudi arbitration law, would be the governing process or procedural law when it comes to the extensions. I'm not personally familiar with other mechanisms through which that would go beyond the Saudi law itself, but perhaps my colleagues here would have other experiences that you might want to share.
No direct experiences, but I think Christian touched on this in his presentation earlier.
He did, and we can provide you some information in a response, a more complete one by email. But I've been given the tea a few times. One last question from this gentleman who's been patiently waiting, and we'll just have a very quick response. If this gentleman can have a microphone. He did have his hand up first of everyone. Thank you.
Okay, thank you, James. Thank you. First of all, thank you for the SCCA for this helpful symposium and distinguished delegates and panelists as well. Just from your experience as a private sector, what would you prefer to see in your dispute settlement articles, as we call it in the investment contracts or in the investment agreements? We call it fork on the road. So we give 3 choices in the dispute mechanism. We give the ad hoc arbitration, the institute arbitration, and the local courts. As a private sector, what would you prefer to see in your contracts? Thank you.
Well, I think we're conscious of international enforcement law and the fact that you may have to choose one process exclusively in order to take advantage. But the issue with drafting contracts is that when a dispute ultimately arises, you have an idea as to where it's going to be best dealt with. If it's going to be mediated, if it's something that you think the local courts would be particularly adept at addressing, or if it's something which is going to have to go to a full formal commercial arbitration. But when you draft the clauses, you don't know what type of dispute is going to arise. And so when the dispute arises, you're stuck with it. You're stuck with that mechanism. You may have something which you think we should be dealing with this before the local courts because it will be dealt with more quickly, but you have an arbitration agreement, or vice versa. So there is an element of prediction and fortune telling as to, well, what type of dispute do we think is likely to arise here? So we look at something that is going to be most flexible and suitable for anything that does arise, because once the dispute arises, you can't re-agree. You won't agree what day of the week it is, so you won't agree on changing the dispute mechanism. So an escalated clause, and I was happy to see the increased growth of mediation. I know Saudi signed the Singapore Convention on Enforcement of Settlement Agreements reached through mediation. And given that I am today, I hope, going to be told that I'm an accredited mediator from CEDA after taking the course, I'm very enthusiastic about the room and the potential for mediation within the region, particularly in construction disputes at a time when there's a perception that dispute process is too long and too expensive. I think people need alternatives, and this is why I'm very excited about the centre's broad approach and full service offerings. So I think some of the problems remain. At the time when you draft the dispute mechanism, you don't know what type of dispute is, but I think at the other end, we're dealing with it by offering flexibility and a broad range of resolution mechanisms.
Brilliant. Thank you so very much, everyone. We're now going to break for lunch, and we look forward to seeing you for the next round. We have 2 excellent panels this afternoon with, I beg your pardon?
I guess James is too hungry. Actually, we're breaking into the next session with the moderator, SCCA Dubai Director Fatma Belfaqih. Sorry, James, you have to wait.
Okay. Thank you, brother. Thank you to Sean, Maria, and Abdullah.